So welcome to title searches and the basics of title searches and recording a deed. So in Virginia, you're going to find deeds in the clerk of the circuit court's office, and the deed will be in the county where the property is located. Almost always deeds are recorded immediately, and this is to avoid fraudulent conveyances. But as between the grantor and the grantee, title is passed as soon as the deed is delivered to the grantee with the idea that, with the intent that the grantee own the property. So really and truly, recording is not mandatory to transfer title, but almost always deeds are recorded immediately because we want to avoid the possibility of a fraudulent conveyance. All right, so each state has its own recording statute, and the recording statutes create the priority in which deeds are recognized. So let's say there is a fraudulent conveyance. You have a grantor who tries to convey a piece of property to more than one person. You would look at the recording statute to see who has priority. There are three basic kinds of recording statutes. The easiest to understand is the pure race statute. And if you were to look in your book, it's on page 319. And if you're in a state like North Carolina that has a pure race statute, it's the race to the courthouse. The first person to get to the courthouse and record the deed, that's the person who has title to the property. Virginia has a notice statute. In other words, the last good faith purchaser, or the last bona fide purchaser, that's someone who takes the property without notice that anyone else has a claim on it, wins. South Carolina has a race notice statute, and the race notice statute works this way. The first good faith purchaser to record their deed wins. So again, a good faith purchaser is also known as a bona fide purchaser, and it's simply someone who takes title to property without notice of a prior conveyance of the same property. All right, so this example is from the book, considered 13.8. Oliver conveys to Al, who's a bona fide purchaser. Oliver then conveys the same piece of property to Bob, who's also a bona fide purchaser, and this is the following day, day 2. Day 3, Al records. Day 4, Bob records. In the above example, who has title under all three types of recording statutes? Well, it's easy if you're in a race state like North Carolina. A wins, right? The first one to record wins. All right, so what if you're in Virginia and we have a notice type statute? And so with a notice statute, the last bona fide purchaser wins. The last bona fide purchaser in this case is Bob, and so Bob wins. If you were in South Carolina and you have a race notice jurisdiction or statute, the first good faith purchaser is going to win. And in this case, the first good faith purchaser is going to be Al. All right, so Ginsheimer versus Knisley, the case on page 321 in your book. In this case, on May 15th, 1985, Gilbert and Vivian Beale executed a general warranty deed to Mark Ginsheimer. He did not record the deed right away, which is probably, in this case, a huge mistake. So September 1985, Kevin Knisley obtained a judgment against the Beals for $124,000. Knisley then recorded his judgment one day before the deed to Mark Ginsheimer was recorded. Now, the judgment lien creditor, Kevin Knisley, now asserts a valid claim on this property. Of course, Mark Ginsheimer says, no, you don't have a valid claim because I had a general warranty deed prior to your judgment. But you know, he didn't execute. Although the deed was executed, he didn't file it. And so the question for the court is this: if Kevin Knisley, that's the judgment lien creditor, is a bona fide is a bona fide purchaser. In other words, does he have knowledge of the prior deed, and he swore under oath that he did not have knowledge of the prior deed. And in this case, since he did not have knowledge of the prior deed, the judgment lien creditor has a superior claim, and he gets the property. So what I wanted to point out here is this. Every time you buy a piece of property, you're going to have a title search performed. And that title search is updated just prior to recording the deed, and it should be. In this case, I think the lawyer made a huge mistake when the lawyer did not record the deed from Gilbert and Vivian to Mark Ginsheimer immediately. And in this case, Mark Ginsheimer is the one who ends up losing big time. The Gephardt case actually comes from Virginia. It's on page 325 in the book. And you can go and you can read the facts in this case. In this case, there was title insurance involved. And the Gephardts had purchased title insurance. And while during their title policy was in effect, an adverse claim arose. Evidently, someone was paying property tax on about 4.75 acres of their property. And so they filed a claim with the title company. And to clear this up, someone was claiming title to 4.75 acres of their land. Well, for estate planning purposes, the Gephardts then transferred all of their property to another entity. They still were the sole owners of that entity, but they transferred their property to an LLC that was wholly owned just by the Gephardts. Now, the title company said, we refuse to pay the claim. The Gephardts said, you need to pay the claim. Title company says, no, because you, Gephardts, don't own this property anymore. Title insurance is not transferable. The LLC has title to the property. You don't have a valid claim. And indeed, in this case, the title company won. Settlement agent. So when we talk about closing later on, we'll talk more about this, but the buyer has the right to choose the settlement agent. And the settlement agent in Virginia is either going to be a title company or an attorney. One of the primary functions of the settlement agent is to perform this title search. And the seller must have marketable title at the time of closing. That's the point at which we look. Because oftentimes when you search a title, you will find that there are flaws in the chain of title. But so long as those flaws can be remedied by the date of closing, then that's all we look at. So you look at whether there's marketable title at the time of closing. In Virginia, and you'll have to know this for the test, in Virginia, full title search goes back at least 60 years. You check the chain of title going back at least 60 years to make sure that there's clear title to the property. And again, as I said earlier, although a title search is performed promptly, as soon as you know there's going to be a real estate transaction, it's updated just prior to closing. So just prior to filing the deed, you do an update to make sure there are no adverse claims. So I know this is not as good as actually going down to the courthouse, but we're going to have sort of a virtual title search, and I'll walk you through the basic procedures. You're welcome to go in the clerk's office anytime, perhaps not during a pandemic, but at any other time. The first step you would take is you would go down to the clerk of the circuit court's office. All of the real estate records now have been digitized, with the exception of just the very oldest deeds. And you'll see here in this picture some of the old deed books, the big fat deed books that are pictured on the left-hand side of this photo. This is actually the Prince Edward County Clerk's office. So you're going to begin your title search by going to the grantee index, because you know who owns that piece of property. And you'll go to the grantee index, and then you will search for the grantee's name and for the deed of the present owner. And this deed is going to make reference, or it should make reference, to the source that the present owner obtained the property from. And this should enable you to establish links in a chain that goes back at least 60 years. All right, so as you're looking at these deeds, to go back at least 60 years, you're going to look at them and look to see whether are there words of conveyance. Are all the proper parties part of the deed? Is there an adequate description? And again, if it's a meets and bounds description, you're going to draw it out to make sure that the figure closes. Are the signatures all there? Are they notarized? And you're going to look at all of this to make sure the deeds are proper. So this would be an example of the first page of a deed, and this is what it looks like. And you'll see it has a description, and anyway, so you can take a look at this, and here's the second page of the deed, and you'll look to see that it was filed, and you look to make sure that the signatures are all okay. Oh, the one thing I wanted to point out is this. In the old deeds, and I'll show you once again, but in the old deeds, if you want to know exactly how much someone paid for a piece of property, you can look at the Grantors Tax. And the Grantors Tax is $1 for every 1,000. So in this case, the Grantors Tax was $110. So that meant that they paid $110,000 for the piece of property. All right, so this is just a form that I made, and this is what I used when I was practicing law. So I would look at each deed, and so I'd note the deed book and page number, the date it was recorded. What kind of a deed is it? Is it a general warranty deed, special warranty, quit claim? What kind of a tenancy is created? Is it a tenancy in common? Is it joint tenancy? Are all the signatures regular? Are the seals affixed? In other words, are the seals notarized? Does it look okay? And then I would write down the description. And the description also is going to refer to the source, the place that the deed book and page number that you will find the deed in the chain of title. I also would note to myself, are there any deeds of trust? Are there any other liens on the property, easements, restrictive covenants that I need to look at? All right, so once I've established that chain of title going back 60 years, then you need to make sure that the grantor didn't convey the property to more than one person, or that there's not an unreleased deed of trust. And so when you're adversing the title, what you would do is you would examine the judgment lien index to make sure there are no outstanding judgments against that person during the time in which they held title to that property. Another thing I would ask myself is, you know, are appliances being conveyed? Is this a real estate transaction where the purchaser is buying the appliances? If so, I'm going to check financing statements to make sure there are no liens against those appliances. And then the other thing I'm going to check is real estate taxes. Are they current? Is there a lien against that property? Remember that real estate taxes have very high priority in terms of liens against a piece of property. I will also check to make sure there are no mechanics liens, also known as material men's lien. So remember, the lien of a person who's worked on a house can have rights that are superior to the owner, can have rights that are superior to the lender. So if it's existing construction, title insurance companies oftentimes just accept an affidavit from the seller stating that no improvements have been made in the last 120 days. If it's new construction, generally what the title company does is they have everyone who worked on the house sign a mechanics lien waiver form. And so all the contractors, all the subs sign this form saying that they do not have any outstanding claims. All right, so this is another form that I would use. So I look at each link in my chain of title, and this is where the form that I would use to look to see, has that person conveyed this property to more than one person? Are there any outstanding financing statements, judgments, taxes during that chain, link in the chain? All right, so this is the screen that you're going to see if you go to the clerk's office. And the best way to do a title search is just to sit down and do it. So you will be doing an RMS search. So as you look at the screen, you just click on RMS and see, and then what that will take you to is the page of deeds. And so you can then put in the present owner's name and look at the deed. And again, all of the more recent deeds have been digitized, and so you can very easily see those. In old deeds, as I said earlier, you can determine the actual purchase price by the Grantors Tax, $1 per thousand. In more recent deeds, they must include a cover sheet, and that cover sheet is going to include the actual purchase price, so you don't have to look at the Grantors Tax. Title insurance. In Virginia, settlement agents are required to tell buyers that title insurance is available. Title insurance, by the way, is a great deal. It's a premium that's only paid once. The one thing that I will caution you about is that title insurance is not transferable. And so we saw the earlier case where a couple in Virginia learned that lesson the hard way. Almost all lenders require title insurance anyway. Title insurance protects you against a lot of things, including your lawyer's malpractice, but title insurance would not protect against new problems that develop after closing. So new encroachments on your property, for instance. Zoning restrictions are not covered by title insurance, and claims that are not noted in public records but are ascertainable by inspection also are not covered by title insurance. So most of these matters are discoverable by a survey. So unless you have a recent survey of your property that you're purchasing, the lender's going to require a new survey anyway. So why do you want title insurance? Well, it's inexpensive. It covers defects that are in existence at the time of transfer. But again, finally, remember the lesson from the Gephardt case. Title insurance is not transferable. Upcoming classes, just want to remind you to please check Canvas for a YouTube link for the Test 2 review. And be sure to complete the problem set, because the problem set may be up to 5 extra credit points added to your next test grade. And Test 2 will be administered on Canvas, and it's proctored by HonorLock. Thank you for listening to Title Search, and I'll see you in class.